My name is Julie Mwaniki, and I am an advocate of the High Court of Kenya. I am a partner at a law firm called Mundui Murai. We're based in Nairobi, but we also have offices in Nyeri and Juja. My areas of practice include technology, media, and telecommunications law, data protection and governance, as well as intellectual property law. I am a certified information privacy professional and a member of the International Association of Privacy Professionals. I am also a member of the Data Privacy and Governance Society of Kenya. And on a day-to-day, what I do is I help organizations restructure and optimize their systems to enable them with the provisions, to enable them to comply with the provisions and requirements of the Data Protection Act. I'm excited to be here this evening, and I look forward to an engaging session.
Thank you. You can see you are loaded. That, those introductions mean, hey, check, count. It is your turn, Victor. Tell us something about yourself. Welcome, everybody. Victor Mumo.
Thank you. My name is Victor Mumo. I'm a quality assurance engineer by profession, working with Workway Africa. I've been in IT space for more than 10 years. Currently managing teams across quality assurance, DevOps, and security. I'm excited to be here, looking forward to this conversation. Thank you, Geoffrey.
Thank you very much, Victor Mumo. Now, lastly but not the least, Nelson Mwai, introduce yourself in such a way that people will remember you. Make it memorable.
Great. Thank you very much for that great introduction. My name is Nelson Mwai. I lead legal operations here at Workway. So as part of my role, I'm tasked with helping Workway set up. We now set up in about 28 African countries, understand how to navigate through the regulatory framework that is involved in all these countries. So I'm an advocate of the High Court of Kenya, certified secretary of Kenya as well. And it's a pleasure to be here, and I look forward to a great conversation.
Thank you very much, Nelson, Victor, and Julie.
Yes.
Let us dive into the discussion.
Yes.
Our discussion today is ensuring data privacy and protection using HR systems. And the most important question, therefore, could be, what is the Data Protection Act? We'll start with the lady telling us what is the Data Protection Act. Briefly, what should we know about the Data Protection Act?
Thank you so much for that question, Richard. The Data Protection Act is an act of parliament that was enacted in November 2019. It is, without too much, founded on Article 31 of the Constitution, which provides the right to privacy. The Data Protection Act primarily deals with natural persons who are individuals like yourself, Nelson, Victor, and Nelson again. And under the Data Protection Act, basically there are categories of data that are protected. The first one is personal data, which is information about a natural person or a human being. The second one is sensitive personal data, which is information relating to a person's race, health status, ethnic, social origin, etc. Basically, any information that can be used to prejudice them. So like membership to trade unions or political beliefs, information about your spouse or your children, etc., etc.
My turns are away.
Very good. That is very interesting. Anything else that you can add, Victor, on the definition of or the understanding of the Data Protection Act?
People say you're too young.
Anything that you can add, Victor?
I think you're.
Yes, sure. So it's not just a legislation of law. So in as much as we are talking about personal data here, what I can add is how do we protect this data? So we need to ensure that the safeguarding of the privacy and the rights of individuals. So the systems that we are using should be able at least to ensure that our data is protected well. But we'll dive that in shortly. Thank you.
How does the HR system get into data protection? Yes, please.
Yeah, it's Nelson here. I
Yes.
actually didn't get the chance to contribute as to the Data Protection Act and what it actually is.
Yeah, go ahead.
Yeah, sure. So maybe I can just give sort of an example. And I was just thinking through this example of why we need the Data Protection Act from a layman's perspective. So take, for instance, you go to a supermarket and every buyer, including the somehow knows your name, where you live, perhaps your dating history, your medical history, your favorite food, your snack, maybe your pleasure. It's very important. And that's exactly how you feel when you have your data and protected in this. Everyone knows your personal business. Now, the reason why we have the Protection Act, of course, Julie has gone in great length to describe when it was actually enacted, the law in Kenya. So the Data Protection Act is actually the friend who insists on walking you home, of course, making sure you're safe and you're sound. So it actually stands guard, ensuring that your right of privacy, which is fundamental, is enjoyed as good as we actually enjoy our Kenyan tea. Now, the Data Protection Act actually draws a lot of inspiration from the European General Data Protection Regulation, what we actually call the GDPR. And it actually, especially in this era of technological advances, there has never been a time when we need the Data Protection Act, like we actually need it now. And by the way, just to put it into context, data protection is not just an issue here in Kenya, it's also an issue like worldwide. According to the data that we have from UNCTAD, 137 countries in the world, out of 194 countries in the world, have actually enacted data protection legislation. And guess what? Even closer home, 33 countries in Africa have equally put on their jerseys and they've joined the data protection team. Now, just to describe what you find in a good data protection legislation, and I'll just define it very, very simply. The first is we have certain roles, and of course, we'll discuss about them later. We have what we call the data processor and the data controllers. It's kind of like deciding who plays as striker, who plays as goalie, who plays as a defender in a football match. Number two, it actually sorts out different types of data because some data should be protected more than other data. It champions the rights of data subjects. That is you, I, Richard, Julie, Victor, and all the other members here today. And it outlines what are the bases of data processing. What are the responsibilities of each of the players in this game, right? So maybe I just thought it's important for me to sort of just give that background so that as we get into the conversation, it's easier for people to understand like what is the basis, what are these definitions, why do we need them, and what is this game that's being played.
Great. And why has it become important? Why now? Why do we have this act becoming the new kid on the block? Why has it been decided that this is a very good act to have within our country?
Great. There are many reasons why it's becoming very important, but key of all is that the right to privacy has never been as important and has never had as many risks as we have. I take, for instance, today, if you just look at how people transact, they transact on their internet. We have so much traffic flow of data over their internet than ever before. Oh, I was just looking at the comment. So if you look at it from the perspective of one, we have a lot of risk to the right of privacy. Number two, we need to protect the right of privacy, perhaps more stringently than we've ever done so. And then 3, we have so many actors. So we have so many actors, that is the data controllers, the data processors, than we've ever had before. So that's why the data protection legislation is taking much more credence than perhaps any other time in history.
Thank you very much. Julie, as your fellow discussants have elaborately told us about what is data protection, why has it become important. Now let us now dive into organizations. Why has the issue of HR systems been lobbed into the data protection? Why is it connected to Data Protection Act? The entire superstructure of human resource, then it's connected to data management. Why is it important?
Okay, thank you so much for the question. And I agree with a lot of what Nelson has said. It's important to set the background for this. So before I get into why HR systems are roped into data protection, I think there are 3 parties we need to identify that Nelson has already identified. We talked about the data subject, which is a natural person. That's you, me, Nelson, the data, etc. Basically a person who can be identified and is identifiable either by their name or their email address or their telephone number. If we use certain information, we can easily identify this person. Then there's a data controller. A data controller is an entity or a person that determines the purpose and means of processing data, especially personal data relating to individuals, as we've mentioned. And then there's a third party called the data processor. I like the analogy that Nelson used about the goalie, and I tried to note that down so you'll repeat it for us so that it's a very good metaphor. So the processor is now a person who does the processing on behalf of the controller, right? So those are 3 parties: the data subject, the data controller, and the data processor. So in HR is essentially all about individuals. It's about dealing with the employees, human capital of organizations. So HR essentially, by dint of its function, is very, very much tied to data protection. And that means it will fall within the scope of the Data Protection Act. So this then gives all HR professionals a very high threshold to meet in terms of compliance with the Act. So there are certain rights that are provided for under the Act, and these rights pertain especially to employees. So employees have the right to be informed of the data that will be collected. They have the right to, when this information is collected, it's limited to only what is relevant for the purpose of the employment. And they have the right to restrict or to give consent to when this information is to be collected from third parties. So if, for example, I'm looking for a job and you inform me that you're going to contact my referees or my former employers, I need to consent to you being able to get that from my referees. And then also background checks should not be too intrusive because I have the right to privacy that needs to be maintained. So when we're basically talking about HR, the Act will require HR to implement certain policies and organizational measures to ensure that the rights of these data subjects, who are the employees, the individuals, are protected. And in this regard, the HR department of the organization will largely be a data controller because they're determining the purpose and the means of processing. And then when they contract an HR, I guess you call it HR MIS system, that system or the third party providing that service will be a processor because they're processing information that is given to them by the data controller pertaining to the data subject, who is the employee, right?
Yeah. Go on.
We're flowing up to there. So you'll find that HR systems largely are hosted by third-party providers such as Workpay. Nelson will maybe touch more on that. And that HR will now collect the information directly from the employees and the data subjects. Then this will be stored on the HR system, which will be controlled by which will be accessed, or certain services will be provided by the processor or the HR system. So some of the information, some of the personal data of these employees is like my ID, my KRA PIN, my NSSF PIN, my NSSF number, information pertaining to my home address, information pertaining to my location, my email address, my telephone number, and then there's sensitive personal data, because a lot of times as HR professionals, when you're onboarding employees, you'll also ask them for next of kin information, which would pertain to information about spouses or marriage certificates, birth certificates for children, notifications of birth. So all this is very, very sensitive personal data that HR is controlling. And especially when this information is uploaded onto these HR systems, it's necessary we ensure that we have the protocols and the procedures in place to protect this data in accordance with the Data Protection Act. I think I'll stop there and give my fellow panelists.
You've done me some good service, because one of the questions that I wanted to ask next was who is a data processor, who is the data subject, who is a data controller. I was in a training today, and one of the first things that was done was for people to sign some forms such that they agree for their data to be collected. The other day, I was coordinating many in HR, and one of the things presenters were told is to sign a form to release their data so that their pictures can be used in social media. So how is this, Victor, how is this collection of data and the signing guaranteed that it will guarantee the safety of your data? Signing of a paper, yes, but how are you safe from the collection of the data?
Thanks, Richard. I think the fact that you're given a paper to sign, that means that they are getting consent from you. And what that entirely means is they are going to be up to protect the data, but there's no guarantee of the data being correct or being stored correctly. What I can say about data protection, there are issues that come around HR systems. And one of the issues is how accurate is the data that is being collected or is being stored. Many times when you're walking into probably a mall, somebody will ask you for your ID. And I don't know how many people think of what happens after they have been left with your ID card, and then how accurate are they going to record that data? What happens to the storage of that data? And when we are talking about like the question that you've just asked right now, what I would say is there are no guarantees, but it is a good thing that one, we seek consent, especially look for a system that at least asks for consent. And once you have asked for consent, ensure that you have sought what access controls are there in place. Who is going to access that data? At what level are they going to access that data? And then after that, ensure that you have a right to review that data. You have the right to have the data deleted. You have the right to get how long are they going to keep the data. Thank you, Richard.
Thank you very much for that very wonderful and very elaborate contribution toward the discussion. Nelson, how should we as HR people assess the competence, so to speak, of a system to keep data? What are the indicators of a good system that will guarantee a little bit of safety? How should we know that a system, an HR system, safeguards the data it collects?
Thank you very much for that. I think it's a very underrated thing when a HR professional is told that before you choose a HR platform, it's important for you, number one, to request them for a data processing certificate. So one of the things about the Kenyan data protection compliance framework is that you're actually required to be registered. If you're a data processor, you need to be registered as a data processor. Then secondly, if you're a data controller, you need to be registered as a data controller. So the first and most important is you must request that HR platform to provide you the data processing certificate. I can tell you without a shadow of doubt that is actually registered as a data processor. And I don't intend to blow a trumpet at all. Then secondly, and very important, is that you must that HR platform provides you with their data privacy policies. And equally, you must ensure that you sign either a agreement. So the way it works is platforms have a service level agreement, and entrenched in that service level agreement is confidentiality and data privacy policies. So for instance, you need to understand how will your data be processed. Like Julie has correctly stated, a HR platform is a data processor, but the data controller is actually the client who's the employer and who has data about the employees. So it's the client that makes the decision, for instance, and says, we need to conduct a performance review. So that is actually instructing the HR platform as a data processor, process your data that you are able to conduct a performance review. That's just one example. So for that to happen is that you need to have signed a service level agreement that must have confidentiality provisions, that must have data privacy provisions, and most importantly, a data processing agreement, also a data processing clause. That said, after that, you must equally require the HR platform provide you with how they're able to, what their technical infrastructure looks like. So what this means, for instance, is how does the HR platform store that data? For instance, who are the cloud provider? Is it Google Cloud? Is it Amazon Cloud? How do they actually store their data? A lot of people don't ask that, but it's a very, very important question. What are their backup plans, for instance? If there was to be a breach of their system, how are we sure that that they have a backup and that your data does not get lost? Understand that as a client who has employee data, there are certain obligations that you have, for instance, payment of taxes. You equally need to store or demonstrate that proof of payment of those taxes. How do you do so if your HR provider, for instance, has a breach and all your data disappears in one afternoon or one night? Last but not least, of course, is the non-technical infrastructure. For instance, I can give you an example. How many times does your HR provider platform conduct sort of a penetration test? How sure are you that their system is impregnable, right? How many times do they train their staff about the protection of data? Because it's inadvertent that the employees are going to access your data, but how are they training, or how many times are they training? How many times are they ringing in the heads of the employees that there's an obligation that they owe not only to the company, not only to the client, but equally to the very data subject whose data is being processed? So I'll just stop there. Of course, I've spoken a lot and just perhaps request for your question.
Thank you, Nelson. You've told us about the processing certificate, data protection. You've told us about performance review, service level agreement, and the penetration tests. Julie, those are very good points to note. Recently, Israel was attacked. I am very sure that their systems were interfered with. Recently, also Kenya was attacked. Our systems, some of our systems were attacked. How do you authenticate and how do you prevent unauthorized access? Julie.
Okay, thank you. So the way we can authenticate access. So when we're talking about authenticating access, it's that we're ensuring that the person who is accessing this information has the right and authority to access the information. So one of the ways we can authenticate is through the use of usernames and passwords. You should have a password policy where the same is regularly updated. And usually passwords should not stay for more than 30 days. Say you should change them regularly so that we ensure that the person accessing the data is the one who's supposed to access it. We can also have multi-factor or two-step authentication. You can have a password or a code, depending on the HR system that you're using, that is sent on email in addition to the password to you, requiring you to put in the password. We can also have biometric authentication. This would require fingerprints or facial recognition, but the way now the biometric information will be stored will also need to be very secure, because biometric data is sensitive personal data. So the system that you implement must ensure that where this data is stored, you have put in place mechanisms to ensure that it is not authorized by, or rather, it is not accessed by unauthorized parties. In terms of authorization, especially with regards to HR systems, we can have role-based access control. So let's say there are different members of the HR department, but there is an overall head of department. So the overall head should be able to access everything with respect to HR, but then you can assign this based on the role. And this is where also the policies, the access-based policies come in. They should define what data and functionalities are accessible to different user roles. So for example, someone, if I work in the legal department, I should not be able, sometimes you'll find that legal and HR or HR and IT want to access the human resource function of one of these HR systems. I should not be able to have the same access as someone in the HR department. I should only be able to see that which is necessary for me to perform my purpose. And then we can also have data encryption. So where data is stored on the system, when it is at rest, as well as when it is in transit, you should ensure that it is encrypted to protect from unauthorized access, so that even if the system is compromised, then the data will not be easily readable by the entity who is sort of trying to breach the data. We can also have attribute-based access control. This one would be maybe like an environmental control or a VPN, where you can only access this information if you're within the confines of the organization, depending on what the organization requires. I think that should be, I'll stop there.
Very good. Let me ask Victor. As I've mentioned, I'm very sure that the Israel system was hacked, even as recently we were hacked. You've realized somebody has accessed, before you even realize, how should you know that somebody has accessed your system? And how do you recover from that inversion of your data system? How long should it take for you to realize that your system has been breached? And how do we put mechanisms in place for recovery?
Okay, I think every good system should have monitoring in place. Ensure that you are able to monitor logs, and you should also have a web application firewall, which also helps you get protected from bad actors, because what happens is before you are attacked, people will gather intelligence about what is it, how your security is. And for the case probably of Israel, for the case of Kenya, people got into systems and tried to hack into security of a particular area, and they will discover that there are loopholes here and there. So ensure that you have a good monitoring system in place. Ensure that at least you have a good web application firewall that at least is able to notify you in case of any attacks or any issues. You should also have clear login, that audit trail of any issues. People could have probably misused their access controls. You should be able to tell that by doing access review regularly and recertifying the user access to ensure that the permissions that you have given them remain appropriate. Then Also, one of the deterrents is ensure that you have in place least privilege principle. What this means is users should only have permissions necessary for their job function and no more. Most attacks are, we say, most of them start internally with somebody who was not able to secure probably their devices or their application well, and then there was a loophole. So security starts with us. I believe if we are able to set proper, as Julia said, proper role-based access control, which enables us to have who is assigned what permission and at what level have they been accessed at. Now, to the question of how do you revert, if there's an attack, you need to have proper backup mechanisms in place. I think Nelson talked about that. Wherever you are hosting the data, there should be a way that you have either backup policies that are on daily basis, that if you lose your data today, you should be able to recover to the very minute. There, you can have active, or active passive. What I mean by that is whenever you are working, there is a backup site, and the backup site could be idle, waiting for either loss or failure of hardware, and then immediately it comes on and you are able to continue working as if nothing has happened. So having put those measures in place, I can go on and on, but I believe having put some of those measures in consideration will help you be secure.
Thank you, Victor. Nelson, as you can see, this is an issue of change management. This is an issue of learning and development. What are the good parameters when you want to check this is a good training? You know, you want to train your people so that they have the requisite skills in data management. How should you design a good training program so that it addresses all the issues? What should you look for? The fundamentals of data management.
Thanks for that question. So I will just speak about the fundamentals of data management as we are supposed to actually train our teams on. So I think the first and most fundamental one, of course, is just understanding the basic obligations under the Data Protection Act. Of course, it would really surprise you that how many people actually do not recognize the difference between, say, a data processor and a data controller, and what actually a data subject is, and what their obligations are in that regard. Number two, what we've actually done internally at WorkPay is that we actually have a list of do's and don'ts, just telling our teams on what they're supposed to do and on what they're not supposed to do. I'll just take you through two things that we tell them to do. First thing, as Victor has said, is that we usually explain them about the risk that they actually pose as users of the system. So what that actually means is our employees are actually the first point of contact should there be anyone trying to penetrate our system. So what that actually means is that the actually obligations, one, something as simple as updating your password. How many times, say, do you abide by the password policy? How many times do you password, for instance? Is it as we've told you to, or is it as, or do you actually breach that obligation? Very simple, but can actually lead to very catastrophic consequences. Number two is the confidentiality. For instance, if you get, if you actually get access to certain data, what do you understand that you're actually supposed to keep them confidential? Do you actually understand that you're not supposed to disclose them to anyone? Do you actually understand that you should not, for instance, share your password with someone who's not within the organization? Very simple, but very, very, very fundamental.
Very good. That is, those are good strategies of or parameters when you want to train your team on how to understand data protection within the organization so that you do not have setbacks. Julie, when integrating third-party components or third-party players into your system. What are some of the standards that you should look at when you are integrating the third-party?
Okay, the first thing that you'll need to do is during the procurement process, vendor selection, you will be conducting thorough due diligence to ensure that, as for example, what Nelson has said, that they have necessary data protection policies and practices, and they actually enforce them. Because you see, this third party is essentially a processor. You need to make sure that their data protection practices are compliant with the Act. You also need to seek legal counsel. That's where people like us come in to review those contracts and the legality and compliance of the integration, so that the information you're giving to these third parties is only that which is necessary. And one of those contracts that we would be looking at is something called a data processing agreement. Now, this data processing agreement will set out what the obligations of the HR system provider are in handling the data in compliance with the Data Protection Act. And it will say basically what information you're giving them, what they're supposed to do with this information, and if they're supposed to transfer it, or for example, if they're storing it on cloud servers, which country are those cloud servers based in? Do those countries have adequate data protection provisions? As Nelson told us earlier, about 137 countries in the world actually do have, but are there systems or are there practices compliant with our Act? So you'll need to check that. And actually, when Nelson has been talking about registration, we register with an office called the Office of the Data Protection Commissioner. The current Data Protection Commissioner is called Immaculate Kasait, and they have a very elaborate website where we can all go and check on certain information or the requirements for registration. So the ODPC, as I'll call them, they can determine whether the country you're transferring this information to has adequate safeguards. If they find that, for example, I don't want to defame any country, but for example, you're transferring it to a country that does not have adequate safeguards, then the ODPC can actually refuse for you to use that cloud-based server. And then also, when we look at the contracts, we look at contractual remedies. In case these parties do not meet their end of the bargain, what do we do? What is the dispute resolution mechanism that we can ensure so that we are not liable as controllers? And then we can also use data encryption. As I said earlier, there's a right to data portability as well, so that you can retrieve your data easily from the third-party service if you decide to discontinue the integration or if you decide to change vendors. And then you should have an incident response plan and an exit strategy. I would just like to maybe contribute to what you had been talking about earlier in terms of breach. Now that you've brought up the ODPC, it's important to note that if you face a data breach, you're supposed to notify the Office of the Data Protection Commissioner within 72 hours. So for example, if WorkPay, let's say it's organization X, and then WorkPay is the entity that is providing the HR system service. If there is a breach, then WorkPay should notify organization X within 48 hours of that breach. And then organization X should notify the Office of the Data Protection Commissioner within 72 hours. And then when you're notifying them, you should notify them of all the actions that you have taken to reduce the impact of that breach. But of course, when you have the necessary security measures in place, then you can also significantly reduce the impact of such a breach. I will stop there. Thank you.
Good. Thank you, Julie. I would like to ask Victor to talk about what are some of the key strategies for data privacy monitoring and evaluation. And lastly, Julie, Julie, you will comment on non-compliance consequences, and then Nelson will finish. Victor?
Thanks, Richard. Briefly, I want to look back on what Julie was talking about. I just want to add two things. And one is you need also to understand your data flows. What I mean is if you're integrating to an accounting system or a financial system, in a payment gateway, you need to know what data moves in between from your system to the third-party service. What purpose does it serve? Determine if there is any sensitive or personal data that is involved in the exchange, and what guarantees are there for its security. Then the second thing that I wanted to add on is on access controls. Ensure, I think we have talked about this over and over, ensure that the third-party service has a robust access control mechanism that limits the data access only to authorized personnel. On to the question that you have asked me, I think I've talked about monitoring, and continuous monitoring and regular updates are very crucial. When we are talking about data security as technology, the threats are evolving every day, and there's some things that we might consider as best practices. One is penetration testing. I think Nelson mentioned it at some point. Regularly perform vulnerability scans and penetration testing of your systems to identify weaknesses. You might not have the capacity, but there are organizations that are specialized in that. You should be able to look them up and you'll be sorted. Then the second thing is ensure that you have written security policies and procedures. What that helps is when you're training your staff, they already know that these are the policy procedures that cover data protection or incident response, and then ensure that they are updated as new threats, as new technologies emerge. Then I think Nelson has kept on talking on regular training. I'll continue saying that employees are our first witnesses when it comes to security. So we need to continue educating them of any latest security threats and best practices. Then I've talked about access control earlier. And then the last thing is keep all software and systems up to date. Ensure that you have a patch management in place that checks any security breaches and you're able to patch them. Allow me to stop there.
Fantastic. Julie and Nelson,
Richard?
in 30 seconds. Yes? Julie and Nelson, in 30 seconds, tell us about consequence management. Somebody sees me in a bar and takes a picture and then uploads it. Do we have case studies of people who have faced the wrath of the Office of Data Protection Commissioner? And what are the consequences?
Yeah, we have a couple of cases where they're called determinations that the Office of the Data Protection Commissioner has decided. The first one is, someone is saying there's no sound, I think. Can you hear me?
Yeah, I can hear you very well.
Okay. So yeah, the first one, I'll give the example of an employee or a prospective employee. So this employee was going to a local bank, and at that point where they were seeking employment, they were told that there will be a background check that would be done. So the company, the bank, did the background check, and then they found that this person had a criminal matter, an outstanding criminal matter for obtaining by false pretenses. So when the prospective employee requested for information from that organization, they were not given that information. And when the ODPC investigated, the company said it's a matter of public knowledge because it is an ongoing criminal matter. But what the ODPC said is that the company should have given this prospective employee all the information regarding the processing of his personal data. So where they failed to comply with this, they can be issued with a penalty or a fine. The fine is up to 5 million of Kenya shillings, 5 million, or 1% of the annual turnover. You can imagine how much that is, whichever is lower. So if you fail to comply with the act, that's what you can get. If you fail to comply with, or if you obstruct the ODPC in conducting its functions, you can also face a fine of 5 million shillings or imprisonment of up to 2 years. This means that also individuals are liable under the act. So you can actually be imprisoned, not just the company will be fined. There's also legal actions from data subjects or from employees, and this will lead to significant financial liabilities in the form of legal fees and the penalties or fines that you'll have to pay. There's also a serious risk of reputational damage, which will mean basically potential clients will not want to engage with your company. There's also the aspect of operational disruption. Basically, you'll have to divert your resources to be able to manage those legal issues, investigations, remediation efforts, etc. Then you'll also be subjected to regulatory investigations by the Office of the Data Protection Commissioner. There's also the National Computers and Cybercrimes Coordination Committee, we call it NC4, which ideally you should be able to report to also when you have a breach. And then, of course, as human resource professionals, you also have your governing body, which you can reports against you can be made, the IHRM. And then basically you will face a lot of ongoing compliance costs, and the cost of rectification will be very high. So compliance with the Act is not optional, it is mandatory. I would like to say that it is not one single event, it is a continuous effort. And so as you are incorporating your HR systems, you should look at it as an ongoing process and aim towards compliance. But don't also panic in terms of now being afraid. The best thing is to have a data compliance strategy, which will start with training and awareness and things like this. Just like we've said, employees are usually the first point of the infiltration in organizations a lot of the time. So when you train them on what they can and cannot do, we'll avoid the compliance issues. And allow me to stop there, please.
Julie, you have exhausted even, I'm sure, what Nelson was going to say has been included in your presentation. Now, I want to open the door for the attendants. Whoever wants to add something, a question, a reminder, an addition, the listeners, you can unmute or you can write on your chat any comment, addition, something that we have forgotten in this very essential discussion. Yes, Susan Otieno, you hand is up. Unmute.
Thank you for the session. It's been quite engaging. I think something to bear in mind is that one of the best ways to integrate these practices into organizations and specifically HR is to build a culture. So in this case, we're talking about a privacy culture. And I think it's important to also note that in Kenya and maybe broadly in Africa, there's a tendency to ask for more than what you need. So most of the times you'll find that people are asking for so much personal data that, you know, like you're literally opening yourself to more liability than you should. So it's important for organizations to build this culture, to look at how they can integrate these practices into the organizations so that we can start to kind of inculcate these more kind of abstract you know, attitudes and situations so that, you know, it's accepted and absorbed, not just through the training, but for people to understand that, hey, okay, I shouldn't be sharing this, or, you know, if I don't have access, then, you know, what does that mean? What are the implications of, you know, the training and in my day-to-day operations in the company? What does that look like in terms of my kind of practices, you know, with my laptop, you know, passwords, etc. And also tackling that kind of stigma or that kind of pushback in terms of people being very used to, you know, for example, sharing your WhatsApp number, sharing your number with someone else and not telling you. You know, there's some very inherent habits that Kenyans have, and this also trickles into the working environment. So it's important to think about, you know, integrating a privacy culture as well. Thank you.
Very good. You brought up a very good point of culture, because we are always told as management students that culture will always eat strategy. If you have a data protection strategy, but the culture is bad, then it will not make sense. There is a question here. What are some of the aspects you have said we can train employees on data protection? Kindly. That is Sauda. Nelson. You can take that one.
Yeah, thanks, Richard. I think it will be helpful for me to share the sort of an internal tracker we use, just showing the various aspects of data protection that you should train. That starts, of course, from the basics of data protection to the responsibilities of employees. And I think I can share that with you, and you can share it with Sauda. It's ways about it.
Oh, great, Sauda. You've been given more meat. Who is going to unmute and say something about data protection culture and data protection systems and the legality and additions that you want to do? Anybody with something burning, you can write, you can unmute. And on that point, just in case, Julie, you want to leave your number to be reached, you know, networking is very important, and we can only network by using phones. Sometimes there are risks, inherent risks. Nelson, if you want to leave your number and you want to be reached, Victor, if you want to be reached, you can leave your number on the chat so that if somebody does advice, they can reach you.
Richard, I have a question.
Yes, please.
I think there's something which was mentioned. I don't know whether I got it well, but I needed a clarification. Where maybe as an organization we have conducted a background check, and does the prospective employee has a right to demand for the report we have received from the background check?
Yeah, there was a case recently. Someone wanted a job, and then they got the job actually, but then when the background check was being done, it was discovered that this person has a matter in some place. Probably, Julie, because you brought it up, you can bring us up.
I can elaborate because it's a matter of public knowledge. I don't think I will be prejudiced to mention the actual organization. So this person had gone for an interview at, let me just say, a local bank. He had gone for an interview at a local bank, and he had passed 2 stages of the interview. And so the final stage was to do a background check. Now they gave him a consent form for him to consent to the background check being done. So the bank then proceeded to do the background check, and upon their due diligence, they found that there was a case that this person was subject to, and it was obtaining by false pretenses. And so the company decided that on that reason, for that reason, he will not proceed to be onboarded onto the bank, onto the company. Now, as we mentioned earlier, the Act is based on Article 31 of the Constitution, which means the right to privacy. And there are certain rights that are inherent, rights and freedoms that are protected under the Act. The first one is the right to access information. So employees, whether they are prospective, whether they are current or past, they have the right to access the information that you hold about them. So whatever information you hold, as provided that they give you the request, you should respond to that request. And ideally, you're supposed to respond within a reasonable amount of time, which should not be ideally more than a month. But you should respond to the information that you hold about them and give in detail. And should they have any further queries, you should also give them an email or a number that they can address their further queries to. And you should also give them copies. So if you fail to do that, you're breaching the data subject's right to their information, to access their information, the information you hold about them. I think I've seen another question.
What about the question? I believe that response from Julie, unless there's an addition, suffices because time is not on our side. Miriam is asking, CRB Manenos, you ask for services, but you're denied because of your data, status, what has been stored at some place regarding your financial history.
If you request,
Nelson, you can take that.
oh, okay, so
Nelson, you can take that. What is the legality of CRB? What is the basis for CRB? Does it have a legal basis so that it can give information to a third party to use? Nelson.
Well, that's a little bit complex because first, essentially the provision of CRB information is not by and of itself an infringement of your data of your data protection rights in any way, or of your right of privacy.
Good. Any contribution? Any additions to our discussions as we wrap up?
I can just add on that, if you don't mind, about the CRB one. Because the CRB, it depends now for the purpose for which, the lawful basis upon which you're processing this information, right? Is it for the purpose of a job? Is it for the purpose of a tender? Like, what is the reason that you're processing this information or you're requesting it? But if you get a negative CRB report and that forms the basis for which you deny a service, if the person who is affected, and under the Act, we talk about individuals, not companies, if the person who is affected is aggrieved, they can request to access the information that you relied upon to form that decision. I hope I have answered the question. Thank you.
In a nutshell, yes, you have. Nelson, you can share our hub joining link so that if somebody is interested in joining our WhatsApp programs and whatnot, they'll be able to join. We do not have any other additional contribution. I wait for Nelson to share the link so that we can pick it and join. It's a very robust way of Jacinta, welcome. You have come when we have finished the good bits, but probably you will be able to get Eda Mwanyumba, your hand is up. Eda Mwanyumba.
Yes. Thank you so much. This one, my question goes to Julie. How do you protect yourself as an employer? Because it seems like it's a vicious cycle. I am doing my due diligence to get information on someone that I want to employ, which is my right. I find information from somewhere where I have filled a consent form and whatnot. Then I come here, someone is demanding, and especially maybe there's a different example, but the example you've given for someone who's being processed under the law for, basically fraudulent behavior, then they're demanding that I share this information. Isn't it already information that is there with them? How can I be held liable for something that they already know? And how do I protect my institution as an employer? Because, where do we draw the line with the data protection? I can train my employees all I want. I can have numerous consent forms because I feel like the consent form is a lower level of compliance based on now what you've told us, the Office of the Data Protection Commission. So how do we mitigate higher risk? Because it just sounds risky altogether, this compliance process.
Julie, take that.
I'll start by answering your question and saying that the aim of the ODPC is not to frustrate employers or to frustrate business. It's just to ensure that the rights of individuals are protected. You will note that the right that the company infringed was the right to access to information, right? It was not necessarily that the employer refused to employ this person, because as an employer, you set out the job description or the requirements that you would want a person to fulfill. So if one of your requirements is good or integrity, good conduct, if you do a background check and you find that the person is not of good standing or is being accused of something bad, then you're allowed to refuse to employ them on that basis. However, if they ask you the information or the reason why you rejected or refused them, you need to give them the access to that information. That's all the ODPC is saying. They're not trying to come in and sort of regulate who you can employ or who you cannot. It's just a right to access. On that note, I would say that organizations need to have privacy notices on their website, basically saying what information the organization holds about different data subjects, who gets access to this information, how the information will be processed, etc., etc. And then another way that you can protect yourself in terms of your employees, you can come up with privacy policies. Those ones are inward facing, which will set out the rights of the employees and what information you hold about them, who has access to this, and so on and so forth. Another way you can also protect yourself is to input in your employment contracts information pertaining to how the organization processes data and the obligations of the employee with respect to the data protection, with respect to data protection. You can also include this in employee handbooks so that every employee at any given point in time, they know what is expected of them with respect to the provisions of the Data Protection Act. So please don't look at it like a thing to punish or penalize employers. It's not, or organizations. It's not. It's just to facilitate the rights of individuals. But perhaps we can touch base, Eda, and we can talk more about it.
Yeah, that is very good conclusion. We will touch base. That is why we have exchanged numbers. We want to keep the conversation going. Join the WhatsApp group. The discussants have given us their numbers. Please proceed and ask them questions. Give them